Okay, everyone seems to be comfortably scattered around and cozy, so we can start. The projector seems to be working now, so I hope we won't get any further problems with it. Ladies and gentlemen, welcome to the session on networking within the law. My name is Janne, and I will be chairing this session for you today. We all know that the days of the wild web are long past now. The laws and legislation has extended to the virtual world as well as the physical one. And we need regulation and legislation on the internet as well, and that's good. And that's something we all should learn to take advantage of. First, I would like to introduce to you Mr. Andrew Charlesworth, a senior research fellow and the director of the Center for IT and Law at the University of Bristol, and he will shed some light on copyright issues. So Andrew, please.
Thank you. Good morning. Today I'm going to talk a bit about copyright and its application in the network environment. In particular, what I'm going to look at is how we ensure that copyright doesn't get in the way of what we want to do in the networked environment. So I'm going to look at some examples of developments that are going on in further and higher education, and look at how copyright, we may have to deal with copyright in order to ensure that those developments progress smoothly. But to start with, I'm going to run us very quickly through some copyright basics. While we tend to get the view of copyright as being some kind of sort of monolithic chunk of law, copyright is all the same the world over, copyright does differ. While there are international conventions, the Berne Convention on copyright, there are still differences between different countries in how they use copyright, how they apply copyright, their rationale for copyright. A particularly interesting difference is between what we would consider to be the utilitarian approach to copyright and the moral or creative approach to copyright. So in the UK and the US, there is a very utilitarian approach. The reason we have copyright law, says the utilitarian approach, is that if we don't give people some incentive to produce works, they won't do it. So we're giving them an incentive. It's an economic incentive. The droit d'auteur theory of copyright says, well, what we're doing isn't utilitarian at all. What we're doing is we're protecting the rights of the author to the correct use of their work, so their work isn't misused. And there's something of a fundamental clash there between this very utilitarian, we are rewarding effort, and something that says, well, we're not really rewarding, what we're doing is we're protecting a right. What we tend to find in the network environment, what we tend to find on the internet, for instance, is the utilitarian model tends, by and large, to be dominant. So when we're talking about the creation, when we're talking about the use of digital works in the network environment, we tend to be talking about copyright in the utilitarian sense. And the utilitarian model, in essence, says, well, there's something of a social contract between the author or the rights holder in the work and the general public. The author gets the utilitarian incentives. They get the right to control the economic use of their work. And in return, the public gets incentives, gets benefits such as fair use, fair dealing. The fact that after a period of time, the work enters the public domain and anybody can use it for any purpose. We have to remember that copyright doesn't just spring from the ether. It is a state-controlled, state concept. Some people say it shouldn't be called copyright, it should be called copy privilege, because it privileges the author or the rights holder above the rest of society. The interesting thing is, of course, before digital works became widely available, copyright, by and large, was a closed book to the majority of us. It was a closed book even to the majority of lawyers. When I did my law degree, a number of years ago now, copyright, in fact, intellectual property, copyright, trademark, and patent was 1.5 weeks of a 3-year degree. That was how important copyright was seen at that time, back in the 1980s. But the terms of this copyright social contract, that balance of the benefits to the rights holder and the benefits to the public, has been a source of friction for a very long time. There have been arguments over, for instance, the playing of records on the radio. The music industry, back when radio came along, said, oh, this is terrible. The radio is going to put us out of business. We won't sell any more records. This may sound strangely familiar. Of course, radio simply increased the market for records, for sales of music. We heard the same thing with tape recorders, and the music industry again says, oh, this is terrible. It's going to put us out of business. People will simply tape their music, and nobody will buy our music, and the music industry will go bust. Surprisingly, of course, the music industry seems to have thrived and survived through the tape boom. And then, of course, we get the video era, and the Movie Pictures Association says, oh, the video is terrible. We can't allow people to video things, to be able to make copies of things, because it will put the movie business out of business. As Jack Valenti of the Motion Pictures Association of Americans said, the video recorder, he said, is to the motion picture industry what the Boston Strangler is to women. Of course, the video industry has not killed the movie industry. In fact, the movie industry now make more money out of DVDs and videos than they do out of general release of motion pictures to the world. But there's this constant battle. The digital environment is a new battlefield, is a new area of friction. But it's part of a chain that stems way back into the past. What are the consequences of copyright? Most copyright laws in the world say that the copyright holder has an exclusive right. They can prevent other people from doing certain things with the work that they hold the rights in. So the copyright holder has an exclusive right to make copies of the work, to have public performance of the work, to broadcast the work. And all of these rights together comprise the bundle of rights that make up copyright. And as we know, we can assign rights. We can sell our right as a right holder to other parties. We can license our rights. We can retain overall ownership, but say to another user, you may license this of us for certain purposes, usually for a fee. And indeed, if you're a rights holder, when you die, you can assign your copyright to your heirs. And licensing is a very common mechanism that we see today, where we, as a copyright holder, say to other people, you can do certain things with our work, but we retain overall control. Software licensing is a very good example of this. And of course, the licensee, the person who has licensed the work from us, is only allowed to use the work under the conditions of the license. And we can set pretty much whatever license terms we want with regard to our work, the use of our work. In the electronic environment, it is very clear that a copyright infringement occurs when somebody copies an electronic work without the authority of the copyright holder or without a license that permits them to do so. And this has caused all kinds of interesting discussions over when you make copies in the digital environment. What happens when I download a web page? How many copies are made in the interim between the web server and my computer? What about the copy that's made in the RAM on my computer? What about the cache on my computer? Are all these things legal copies? And the law generally has said, well, yes, these are fair use, these are fair dealing. It is necessary to make these copies in order for the system to work properly. But that wasn't a given when we started looking at copyright. These things all had to be discussed and negotiated. And as we've seen over the last probably 10 years, the ability of the public to have mass access to digital works has totally changed the dynamics of copyright. When we look at digital copies, we're looking at relatively easy access to these, to music files, for instance, over the internet. We're looking at perfect copies every time. It's not like photocopying a journal article half a dozen times, at the end of which you can't read the article. It's perfect copies. It's mass distribution. One person acting as a P2P node can do almost as much damage, the music industry says, as somebody running a CD farm in China. And of course, this has led us into the copyright battle in this area. And we see the rights holder groups, key rights holder groups like the music industry, like the film industry, like the publishing industry, saying we now need more protection. The environment has changed. We need more copyright protection. And we've seen over the last 10 years how this lobbying has translated into changes in copyright law. The term of copyright, the length of copyright has expanded. So from being, in some jurisdictions, 25 years, it is now the author's life and 70 years. So you can be looking at a copyrighted work being in copyright for 120, 130 years. We see things like fair use and fair dealing, the public's ability to access works without needing specific permission from the rights holder, being weakened. We see copyright legislation starting to include protection for digital rights management. And we see rights holders being increasingly keen on pursuing not just major infringers, but individuals, as we've seen with P2P, MP3s, and the like. So what we're seeing, in essence, is a slight unbalancing of that social contract. The rights holders are getting lots of new powers because they're claiming that the digital environment puts them at a significant disadvantage. And the public is getting less and less. There's less fair dealing, less fair use. The stuff doesn't fall into the public domain as quickly. And even if it does fall into the public domain, if the work is protected by a digital rights management technique, it may still not be accessible to the general public, even though the work itself is out of copyright. That having been said, all of these things are taken into account. Any thriving education and research sector needs an information environment where information is relatively free-flowing. We're not saying we need an environment where there are no intellectual property rights, but we certainly need an environment where restrictions are kept to the minimum required to provide rights holders with their side of the copyright bargain. As we know, accessing information in the paper world was quite an inefficient way of doing things. If I wanted to research in my particular area and I wanted to look at particular journals, I had to go to the library, or I had to go to interlibrary loan. Now, of course, most of my journals in my area are available online. It's very easy to access them. But what it's also increasingly easy for rights holders to do is to fence those works off. To say, well, you can't just go to a library and read this stuff. You have to go through our electronic holdings, and you may have to pay per time you access that journal article. There's better fencing, there's better policing. If I access a journal article, I may be accessing it under terms which say I can't lend that article to anybody else, even though in the paper world I could have done. And it's quite easy to police these kind of restrictions. Now, quite often in the educational environment, we see this as a problem. We see the increase in rights granted to rights holders as being totally negative. But we forget, in educational institutions, we create a lot of works. We are rights holders. Our academics produce all kinds of valuable pieces of work. So while we have to become rather more efficient than we are at present at ensuring our copyright compliance and ensuring that that which runs across our network is not infringing, we also need to be thinking very much about how we protect the stuff that we own, our own works, how we disseminate those in a way that suits the environment. We may say, well, as an academic institution, we're not too bothered about the rights in this. What we're bothered about is the effective dissemination of our work. So how do we ensure the effective dissemination of our work without finding that work being fenced off, being commoditized, being removed from circulation? To look at some examples. Virtual learning environments. We're seeing a great increase, certainly in the UK, in virtual learning environments. Environments where students have access to digital works, have access to interactive domains with tutors between students themselves. And quite often in the process of working in these virtual environments, we have a constant creation of new works. They may be created by staff and placed on the VLE. They may be created by students. And this is quite an interesting area from a copyright point of view, the creation of valuable digital works by students. We see existing works, paperworks, being digitized, and we need to know how that affects and is affected by copyright. And we see works being reused, repurposed, being used in ways in which their original creators perhaps didn't envisage or even intend. And it's important for us to know who owns the copyright in those learning objects. It's important for us to know what we can do with those objects. And in particular, it's very useful to know how we can track copyrights in digital works. And I think this is one of the weak areas at the moment in education, is being able to track each digital work, each digital object, and who owns the rights in it. And it's worth thinking, as we create virtual learning environments, what rights do we want to protect? How open do we want our virtual learning environment to be? So if we're going to want to protect the rights of others because we're obliged to protect the rights of others, how far do we want to extend that protection to our own works? Institutional repositories are another very up-and-coming development. The idea that institutions will collect the works together that their academics and perhaps their students are creating and store them in a repository at the institution that may be available to everybody in the institution or may indeed be available worldwide. People see these as quite a key resource for the future. But there are all kinds of interesting questions about what you can put into institutional repositories. Now, in UK copyright law, if an employee creates a copyrighted work in the course of their employment, that copyrighted work usually belongs to the employer. However, universities in the UK have not been very diligent at pursuing those rights. They quite often allow their academics, particularly in written works, to sign those rights away to publishers. And if your academic has assigned their right, sold their right in a work to a publisher, that publisher can stop you putting that work in your institutional repository. We've had examples where, for instance, academics at an institution have written a paper, they've assigned the rights to a publisher who's published it in a journal, and the academics wanted to then put the journal article on their internal website for their students to use. And the academics written to the publisher and said, can I put this on the internal website? And the publisher said, yes, of course you can. That'll be £2,000, please. Now, if the institution had had a policy that said, well, we don't assign our copyrights, we license our copyrights, and one of the license terms is that we are allowed to place our work in our institutional repository for access by students, staff, and others, that problem could have been avoided. But institutions, educational institutions, have not played this game terribly well. The situation with universities and students is even more difficult because students are not employees. The university does not automatically own the rights in student works in the way that they will automatically own the rights in employee works. Some institutions simply put in their statutes and regulations, any work that is carried out by students in the course of their studies belongs to the university. It is highly unlikely that that will stand up. We need to be thinking a lot more carefully about the relationship we have with students and the use we make of students' work in the future. We need to be thinking about how we structure the processes for obtaining student permission to use their works in the future. And certainly to move back to academic work, when we're looking at academic work, we need to be looking at how academics reach agreements over publication. Are they going to assign their works? Are they going to go for exclusive licenses? Licenses which are then, all licenses which then allow academics to put materials in institutional repositories to reuse their works? Are we going to look at agreements that allow academics to put their publication in preprint repositories? The publisher publishes the final work, but the preprint goes into a repository that's open access. We may be looking at different models of publication, including the author pays model. All of these things need to be thought about. We've done quite a lot of work in further and higher education in the UK on e-portfolios, lifelong learner records, personal development portfolios, records that the students take with them throughout their educational career and indeed beyond. The plan is eventually that a lifelong learner record will be just exactly that. From the moment you leave education, pretty much till the moment you die, you will have a transcript, you will have a personal development portfolio. And there are all kinds of interesting issues arising out of that in the UK. Lots of institutions are producing their own e-portfolio systems. Some of them are producing them in consortia. And there are interesting questions there then about who owns the software. Who actually owns the software in which the e-portfolios are held, on which the system runs? Again, I think I would have to say UK universities have not been terribly good about writing intellectual property agreements into their consortium partnerships. We need to think about who owns non-student created data in e-portfolios, whether we want to treat it as an ownership issue by universities or whether we want to treat it perhaps as some kind of stewardship issues. We look after this data on behalf of students. We also need to consider who owns the rights in the works that students create and place in their e-portfolios. Whether they place material that is relevant to their coursework, whether they're placing, if they're research students, research outputs into their e-portfolio. Who owns that stuff? It becomes particularly important when you start to look at PhD students who may be working on very interesting work that they'd like to put into their e-portfolio, but they're sponsored by a company who has a confidentiality interest in the outcome of their research. How do we handle those kind of education/commercial conflicts? What should our strategy be for dealing with copyright in further and higher education? There are a number of groups now looking at exactly these kind of issues. The Zwala project, which is a joint project between JISC and SURF, looks very much at how education institutions should be approaching the licensing in and licensing out of copyrighted works that they are using and creating. And I think we really do need to inculcate a more professional attitude amongst educators. We need to be more professional about how we deal with our licensing issues. I think in the past, certainly UK universities have been very lax on dealing with how they license in from other people and license their works out elsewhere. And I think there is scope for a lot of policy and guidance from sectoral organisations like GISC, like SURF, on how you're going to do this. How are we going to handle ownership rights? How are we going to handle use, reuse, and repurposing of materials? The other thing I think we need in the digital environment is a lot simpler sort of rights registration and rights clearance mechanism. A lot of academics, when they are clearing, or they should be clearing, rights in particular works so they can use them on their course, don't do it. Do they do it because they're inveterate lawbreakers? No, they do it because it's too difficult to run through the rights clearance system at the moment. It's too difficult, it's too time-consuming, they can't do it. In the future, we won't have that excuse. So we need to ensure that our academics have access to simple rights clearance mechanisms. We also need to be thinking a lot, I think, about how we use copyright to our advantage. How we use copyright to keep information in the public eye, to keep it from being fenced off, to keep it free and available. And there's a lot of very useful work that sort of stemmed on from the open source movement. In particular, the development of the Creative Commons model for non-software related works. And the Creative Commons model provides a very simple, very visual setup system for allowing people to decide what their work is going to be used for, when it can be used, how it can be used, and then providing that in very clear, very visual terms to end users. I think there still remains a lot of work to be done in this area, a lot of research and development in particular, on standardized rights metadata for digital objects. How are we going to do that? We need to be a lot clearer as institutions about what we expect to see in our licensing agreements, both the licensing agreements we sign to use other people's works and the licensing agreements we provide to other people to use our works. There isn't a great deal of uniformity, and that causes problems because people don't understand what they're signing. And I think we also need to make the copyright system as clear as possible for our end users, in particular for our academics. We need to make it very clear to them what it is that they are agreeing to when they sign up to use a particular piece of work. I'll leave it there.
Thank you very much. I think we have time for at least one question. Anyone? Okay, back there, please wait for the microphone since this is being webcast.
As everyone knows, the music industry and the film industry have been trying to get governments to enact laws saying that you are not allowed to manufacture, sell, or use technical equipment which allows you to make copies of digital objects. And this very often infringes on your fair use of the objects. I've heard that the Canadian government has decided to enact a law saying that the music industry and film industry are only going to get these rights to prevent this kind of prevents use of this kind of technology if they ensure that you get fair use. Is that right? And isn't that a very nice solution to this question?
Thank you. The Canadians certainly seem to have a very different approach to copyright than their neighbours across the border. Certainly the courts so far have been very keen not to expand copyright to the point where it encroaches to a very large degree on the rights of the public to fair use and fair dealing. I couldn't swear to you that I know exactly the way the law is going to develop, but I would not be at all surprised if that was the case.
Anyone else with a question?
Thank you. Ivan Roja, my question is, you said the British law, it's a question regarding copyright law and employees' work. The Czech copyright law from the Czech Republic says that you actually the work that you do for your employer belongs to the employer, but if an employer wants to broadly use it somehow, he has to pay you extra money because then it becomes an extra work. So teachers are pretty much happy with that, but what does British copyright law says about it?
The situation in the UK is not like, as I said at the start, there are broad similarities in copyright law worldwide, but there are also some very significant sort of national differences, and I think that's a very significant national difference from the UK. In the UK, what the law says is that the employer is essentially the first rights holder of any work that is created by an employee. There is no provision for employers to pay more money or anything along those lines. The work is simply the property of the employer. It does make for some interesting situations in terms of working out when you are actually doing work in the course of your employment. I mean, my contract as an academic says that my work is such hours as are required to fulfill my teaching and research duties, which could, I guess you could say, was a 365 days a year for every hour that I'm awake. It's sometimes explained in the UK as if it is work that I am my job contract would seem to cover. So writing a journal article, as an academic, I'm expected to write journal articles, I'm expected to write books. That's part of my employment, therefore that would seem to be my employer's work. If I spend my time at work writing poetry, I'm not paid to write poetry. So that work belongs to me. On the other hand, my employer could of course fire me for writing poetry on work time.
Okay, thanks again. Next, we will hear from Mr. Marko Bonaš, who is the Director of Academic and Research Network of Slovenia, and also a member of the URID board. As you know, the internet top-level domains are regulated, and Marko will be talking about the new top-level domain .eu.
Good morning. I'm Marko Bonaš from ARNES. ARNES is primarily academic and research network for Slovenia. It is also registry for SI domain for Slovenia. In this role, we are somehow also involved in a new top-level domain EU. European Commission got EU top-level domain some time ago because they wanted to propagate European visibility, and they also made two regulations how this registration should run. These are 733 in 2002 and 874 from 2004. I will make the pointers to these regulations later. And the European Commission made public tender to choose who will run this, registration, and organization URID was chosen to do this, and I will describe this later. In this talk, I will only describe the main lines of regulation if your university or you will be eager to register your project under EU, how to do this. Well, URIT is not-for-profit organization established in Belgium and has been selected, as I said, by the European Commission to operate this EU top-level domain. URIT has 5 members. These members are operators of country code top-level domains for Belgium, Italy, Sweden, Slovenia, and Czech Republic. Well, in short, how to get an EU domain? First, I have to say it's not possible yet. It will be possible at the end of this year or in the first months of next year. But here are the steps which have to be followed. First, you will have to choose a name. There are obvious technical limitations, as in all other countries. The given name should be available. It will be possible to find this in WHOIS. Everything will be done through accredited registrars, not through registry, but through registrars, and the list will be available on URIT webpage. This URIT webpage is already alive, but the list is not yet there. And you will be able to register in all official EU languages, so there will be registrars which will be able to speak with you in all EU languages. You will have to read terms and conditions. The most important point is that you will have to submit to alternative dispute resolution if it comes to it, and it will also be possible that you lose a domain if you lose this dispute. You will have to provide the data, and the most important thing that you will have to provide valid email address, and you may lose a domain name if this email address will not be active and if nobody will reply to email. You will register with a registrar, and the registrar will do an online transaction with a registry. The registration will be valid for 1 year, and the fee will be debited from registrar account, and you will pay to registrar. URIT will update the server 5 times a day and put all the data in WHOIS. The most important thing is that everyone will be able to find who is behind a domain, to argue maybe that he should get a domain instead of you. What is important in this registration is that the European Commission wanted to have a sunrise period to give holders of prior rights some priority. And this sunrise period is a very complicated thing. Also, during sunrise period, later the registration will be done on a first-come, first-served basis. But before that time, in 4 months, those who have some prior rights will be able to register before others. Here we see what are possible sunrise applicants: undertakings having the registered office within the EU, organizations established within the European Community, and natural persons resident within the community. And which domains can be registered? In phase 1, public bodies will be able to register their full name, their acronym, and the territory which is governed by them. And holder of trademarks will be able to register their community or national trademark. Well, this phase 1 is fairly simple. Phase 2 is more complicated. Any holder of any rights will be able to apply for a domain which is equal to either company name, either business identifier, either distinctive title of protected literary and artistic work, either unregistered trademarks or trade name. And because laws are very different in different European countries, it will be very difficult to decide if you have a right or not. And it will maybe take months or years to resolve all this. But the European Commission was very firm on this point. Well, how can I apply for EU name during the sunrise period? Again, you will have to go through accredited EU registrar, in addition to usual information required, who you are, your contact details, and so on. You will have to claim the domain name and under which law the right is granted. You will have to send information on paper. Then, if more than one valid application for the same name is received, the application will be assessed on a first-come, first-served basis, because probably many applicants will try to get the same name. For example, French supermarket chain will probably want to register Giant, and Dante will also probably want to register Giant if it's trademarked for Dante, and it will be registered on a first-come, first-served basis. And there will be an additional application fee charged during sunrise, because it's a complicated process, and this charge will be between 30 and 90 euros, 30 euros for simple cases for registered trademarks and public bodies, and up to 90 euros for unregistered trademarks. EURID has already appointed PricewaterhouseCoopers as a validation agent who will authenticate the proof and advise if an application is accepted or rejected. And nobody knows how many applicants will come. Some are afraid that there will be millions. Well, under an application for a name is accepted, or all applications for that name are rejected, the domain name will be blocked from being registered for any other party, even later after sunrise period. And the fear is that if there will be many conflicts here, that thousands or even millions names will be blocked for several months or even years. And during sunrise period, there will be a special EU sunrise whois, where you can see how many applicants are for the same name and so on. There are several other things. Some names will be blocked and may never be registered. Member states were allowed to submit a limited list of broadly recognized names with regard to geographical and geopolitical concepts. And that names will never be registered. This list will be published on EURID webpage, but EURID hasn't received yet the list from the Commission. For example, if Germany put Berlin on this list, nobody will be able to register Berlin. Also, codes will appear in ISO 3166 list. That means country codes will not be able to register by anyone. Then there are names which are reserved for registration only by European Commission or by governments of member states. So member states can request that their official name and the name under which they are commonly known in one or more of the official languages of the EU cannot be registered directly under EU by any other person other than their national government. Only German government will be able to register Germany or Bundesrepublik Deutschland and so on. Candidate countries and member countries may request that their official name and the name under which they are commonly known cannot be registered directly under EU. That means Switzerland can ask that Switzerland will not be registered until Switzerland becomes a member of EU. But the problem here is that it's no provision for European countries which are not candidate countries and which are not in European Economic Area, for example, Albania. So there is no provision that somebody registered Albania, and it's not fair, I think, towards Albania and other countries which are not candidate countries and which are not member countries of European Economic Area. So these countries should protest with the Commission. They have still some months till December when the whole thing begins. And then the European Commission may request that a list of names are reserved by the Commission for use by the community institutions. This list was not yet provided. For the deletion of the name, it will go through quarantine, so a name will be put in quarantine for 40 days if registration is not renewed, for example. And when the name is in quarantine, it will not work, so the DNS will not work. But the holder can change his mind and register in this period. And after 40 days of quarantine, a domain name will be freed for others to register. There is an alternative dispute resolution procedure set up. So this procedure will be compulsory for the holder and for the URIT. The fee for ADR shall be paid by the complainant and not by that party which will lose. The language will be the language between registrar and domain name holder. So that means that you will argue in your own language. The complaints and the responses have to be submitted to an ADR provider. There is currently one Czech arbitration court applied for this, and there is still a possibility for other organizations to apply to become an ADR provider. And the prices for ADR with this Czech arbitration court are already known. They are between 3,000 and 6,000 euro. But here are also included translation in some languages, publication on the web, and so on. So this price is rather low. And when all the papers come, then URIT will suspend the name involved from cancellation on or transfer until the dispute resolution is complete. Failure of any parties to respond will mean that that you lose, in simple words. And here are the rules when you lose the name. There are three conditions. Registered name shall be subject to revocation where that name is identical or confusingly similar to a name in respect to which a right is recognized or established by national or community law. Second, has been registered by its holder without rights of legitimate interest in the name, or has been registered or is being used in bad faith. I think that trademark holders and holders of other rights are well protected under these rules, because these rules are slightly different than WIPO rules. WIPO has an end between the last 2 points. Here, you can lose if first and second point or first and third point are fulfilled. WIPO claims that all 3 points have to be fulfilled. So the European Commission wants that trademark holders or other right holders are more protected than WIPO thinks is appropriate. Well, in case that ADR panel decides that the domain name should be revoked, it shall be also transferred to the complainant if the complainant applies for it, of course, and if it satisfied eligibility criteria for this. And to conclude the timetable, now in June, first registrars will be published on URIT webpage. I think this will be done in the middle of June. The list will be ordered according to the fee, to the money they will pay in advance, because registrars will be required to pay in advance. The minimum fee will be 10,000 euros, and then for each registration, the fee for each registration will be deducted. One registration will cost, I think, 10 euros, but in advance they will have to give 10,000 euros. But if somebody will give more, and some are prepared to give 1 million euros, they will be on top of the list published on ULIT webpage, because there will be probably thousands of registrars. In August, September, there will be terms and conditions of registration in all official EU languages. The main points are already written in this EC regulation, but more details will be available in August and September and in all official EU languages. Then at the end of the year, first phase of sunrise period will start. It will last 2 months, and then after 2 months, the phase 2 of sunrise will start, and after 4 months, that means in March or April next year, the registration will be open on a first-come, first-served basis. And if you are interested to register something under EU or to become a registrar, you will get more information on this webpage. Thanks.
Thank you very much. Any questions, anyone? Okay, down here.
You mentioned payment for use of the alternate dispute resolution mechanism. I'm assuming the person making the request does the paying, not the person who holds the...
Yes,
That's
yes,
right.
and the price is dependent if you want one judge or the panel of 3 judges, so between 3,000 and 6,000 euros.
Thank you.
Anyone else? Okay, thank you again. Next, I would like to introduce to you Mr. Andrew Cormack, the Chief Security Advisor of Ukerna, and he has been previously the head of the Janne service. He will talk about network privacy and how to comply with the network privacy laws.
Yeah. Good. I managed to find the right switch. I'd like to make 2 points, really, starting from the title slide. One, I'm not a legal expert. I'm a third-year law student. However, I would claim to be as much of a privacy expert as anybody else in this room, because privacy is all about personal feelings, and I have some of those. Also, although this is presented in the context of network performance measurement, the principles would actually apply to almost anything where personal privacy might be an issue. Those who were here for the plenary session this morning might like, as an exercise over lunch, to think about how the principles would apply to the sensor network tracking your supermarket trolley that we were presented with this morning, which raised a certain number of privacy eyebrows, I think. I first got interested in privacy when I was a system administrator running web caches, mail servers, file servers for a university. I was root. I could do anything. I gather in some corporate organizations, people with roots do everything. You hear horrible stories about people, system administrators meeting round the water cooler and discussing the email messages they have read today. That feels wrong to me, and yet when I was in that position I couldn't find anything written down to explain why it felt wrong. Since I've come to this job, I've become aware of this stuff called law, of which there is quite a lot. And actually when I look at the law on privacy, particularly the European law, I find that actually it matches quite well with my personal feelings, which is the way law ought to be. But it does mean that if you are in those positions where you are able to or technically able to break other people's privacy, the law may be quite a useful guideline for you in finding out the circumstances and the controls in which, under which circumstances you ought to be doing things to break privacy and which circumstances you ought not. So the presentation is very much in the hope that it will be helpful in keeping you happy as well as in keeping your users happy. Because I know when I was in the university, a number of us sysadmins used to have really quite pained discussions in the coffee room about, we've been asked to do this, but is this right? This may be strange to hear that system administrators do actually worry about these things. We may like to present ourselves as complete gods, but we worry. So, in the context of network measurement, network performance measurement, I think if you read my CV, I'm originally a mathematics graduate, and mathematicians live and die by their definitions. So I like to have almost every presentation, I have a slide of definitions. Three terms which I think are starting to become standard in this area. Active measurement is where the person doing the measurement generates the traffic that does the measurement. So going back to when I started using networks, this is ping, this is traceroute. I'm actually generating a packet saying go out there and do measurement, and a response comes back. So although I don't strictly generate the response packet coming back, so I'm aware there's a ring on this. Sorry. Try clip it there. That's a bit better. Although I don't actually generate the ICMP echo response, in some way I have caused it to happen. I did say when I gave this talk before that therefore there is no privacy issue. A router vendor took me to one side and said, you do realize there are certain systems where the echo response packet will be filled with some data from a random part of memory. So there may be privacy issues. But in general, if you are running your measurement against a device which is supposed to be there for doing measurement, or at least where it's an accepted part of its function, there's probably no privacy issue in doing active measurement. Other things, grids are quite interested in understanding how much bandwidth is available on a particular chunk of network, and they will generate a large but short burst of traffic, essentially to try and fill the remaining bandwidth. There's no privacy issue there. There may be a denial of service issue, but again, probably not a privacy issue. The second type of performance measurement is what I've called passive monitoring. And that's where you're using the traffic that's already there to find out stuff about your network. Certainly, classically, things like NetFlow, where you're just looking at what flows are going from where to where, what kind of protocols, or at least what port numbers. But critically, looking at other people's traffic. This isn't traffic that you've generated yourself. So there probably is a privacy issue here, or at least it's something you need to be aware of. In legal terms, and actually in people terms, though maybe not in technical terms, I think it's also important to distinguish interception, where rather than looking at the headers of other people's traffic, the fact that traffic exists, the number of bytes, you're actually looking at the content, what's inside the traffic. Technically, there may well not be much different. You're probably attaching the same sort of device to the network. Quite possibly, the router that can give you NetFlow stats could also give you stats about what's in the packets. But certainly as a user, I feel there's a huge difference between you looking at the header information, which actually you've got to look at anyway, because unless you look at the header information, my emails are never going to get there. But a big difference between you looking at that stuff that you have to look at and looking at other stuff that you don't need to look at, other than, and a point Andrew didn't stress, copying the bytes of my copyrighted presentation. Any of you looking at this on your laptops, how many copies of this copyright material are there between the core web server, which I think is in Amsterdam, every router on the way, every switch? is taking the packet off the wire, putting it into memory, and putting it back on the wire. That's a copy. Until the law, fortunately, decided it was a legal copy. It wasn't immediately clear. But there's a difference if you actually sit down and start staring hard at the content of my traffic. So privacy issues. Fundamental thing, if you are looking at somebody else's traffic, you have the capability to breach their privacy. Stop thinking like network managers, network researchers, think like people. We are all users too. But looking at headers is less serious breach than looking at content. Because you have to look at headers anyway, just to do the stuff the user wants you to do. Don't underestimate, however, just how serious a breach looking at headers could be. Now, if you have NetFlow data from a machine whose IP address you may not know, you don't have the DHCP data to say what it is, but I've registered a PTR record saying Andrew Cormack's pc.ukerna.ac.uk. So you've now got personal identifying information falling into your hands whether you like it or not. Suppose you find a flow running from that PC to a medical support center. Suppose you are my employer and you discover that there is a large flow from my desktop PC to, let us say, the website of my trade union. Now, I'm only looking at headers. There's no real privacy breach here. Well, actually, there's quite a big privacy breach. And in the case of health data, health information, union membership data, political parties, I think, are all types of data that actually has specific legal protection because the law recognizes that people feel that is more sensitive data. But there may be ways you can reduce the breach. If you take all the traffic coming out of Ukerna, you're actually only interested in what protocols Ukerna uses, lump it all together, there's less of a privacy breach. There's not no privacy breach. That might not be a set of figures that Ukerna would like to have published. I don't know, I haven't looked, but we might find it deeply embarrassing that we don't run voice over IP. We're a network provider. You lot might expect us all to have our phones running over IP. They don't. This is potentially damaging in a small way to the organization. We're working on it. So it can reduce the breach, but it's unlikely ever to eliminate it. So if you go back to my definitions, passive monitoring and interception are always going to breach privacy. Active measurement probably doesn't. And because people are concerned to protect privacy, and by and large we get the laws we want, there are some horrible examples where small pressure groups got the laws they want. See Andrew's talk earlier. The laws exist to protect things people are concerned about. So if you are doing something that's likely to breach somebody's personal feelings about privacy, you may well be breaching a law somewhere. So, what laws? This is trying to look from a European perspective. In fact, within the member states, the relevant law pretty much does come from European law, so there's a certain amount of commonality. Active measurement, as I've said, probably no legal issues as long as you are measuring against targets that are there for measurements. If you start running ping traffic across somebody's internal network, they're not going to turn around and say, yes, fine, no problem, no privacy issues. But as long as you do reasonable things, there probably aren't too many legal issues. Passive monitoring, where you're looking at headers. There's two directives, apologies. Marco had two directive numbers. Two regulations. I had two directive numbers, 9546 and 2058. You will note that the European Commission had a Y2K issue with its numbering scheme. They haven't, fortunately, gone back and renumbered the old ones. Otherwise, an awful lot of law textbooks would have to be updated. The Data Protection Directive, 9546, is the fundamental now statement of European protection. The Electronic Communications Directive, 2002-58, then applied that sort of set of principles to the specifics of running public communications networks. So it has a very, very specific list of the reasons why you're allowed to collect data if you're a public network. There is then, in most countries, some sort of law of confidentiality that says that, yes, flesh and blood individuals have an expectation of privacy, but organizations, universities, colleges, companies have some sort of expectation of something you might call privacy, you might call confidentiality, but that they also have some data that it is not reasonable to publish completely widely. So there are those two sets of laws. If you're then looking at interception, you run into a much older law, the European Convention on Human Rights, which was originally written in the 1950s, I think, and specifically Article 8, which says that every individual, and it is just about individuals, humans, has a right of respect to their private communications and private life. That's it. I haven't got the quote it quite right, but that's all there is in Article 8. So whereas the directives are pages and pages and pages, on the interception side you've just got this one fairly bare statement. And because most of the stuff you collect by interception will relate to a person, interception you're also going to be covered by the data protection and electronic communications law above. So those are the things to be aware of. Can I break privacy? Yes, says the law. The law says there is such a thing as privacy, but it is not an absolute right. If you look at the European Convention on Human Rights, there are absolute rights. The right to life, the right not to be enslaved, and the right not to be tortured, I think are the only three absolute rights. I'm getting a nod, good. The exam on that was 2 years ago. All the other rights are relative rights. They're conditional rights which can be breached if necessary. So you can breach the Article 8 right of one person if it is necessary to do so to protect, for example, the Article 8 rights of another person, or to protect the right to life of another person. So the fairly common circumstance that comes up, or is quoted, I hope it's not that often, is where somebody makes an emergency call, 999, 911, whatever your number is, not yet standard in Europe, and the emergency services can gain access to location data about the caller ID, about where a mobile phone was. Huge breach of privacy, huge breach of Article 8, but in order to protect the possible threat to somebody else's right to life. So there's this balancing act in all these privacy rights. The words in the, mostly coming from the convention, but also in there, but expanded over several pages in the directives, is that rights have to be necessary, or breaches have to be necessary, they have to be proportionate, and they have to be controlled. Good European words, proportionate especially. If you see proportionality in anything, you can be sure it's a European document. But these are very much how we feel as individuals. You can break my privacy if you need to, if you have good reason. That's necessary. You can break my privacy so long as you don't do it more than you have to for that purpose. Proportionality. Balancing the harm that's caused by the breach of privacy against the benefit that you gain. And that benefit can be harm doesn't happen. So you can actually say, is the risk if I don't do this worse than the risk if I do? And if, which way around did I get it? Yeah, if the risk in not monitoring the poor performance of your network is worse than the small breach of privacy that you do by monitoring the network, then the law says, yes, fine, go ahead. But the third thing it says is you must be controlling that breach. So you must have clear policies that ensure that stuff is done in as unintrusive a way as it can be, that the data you collect is not then used for something else. Remember the supermarket trolley. Now, the supermarket, I think the example was given was the supermarket wants to see where trolleys stop to see which adverts are getting people's attention. Probably not a problem. If you average it out over a day, over a week, oh, wait a minute, you know, the average stay in that area of the supermarket was 5 minutes, the average stay in that area was 1 minute. The example I thought of earlier, okay, our frozen food compartments are too far from the checkout. You know, people are going to the frozen food compartment, they're then spending an average of an hour wandering around the supermarket. You know, we have a health risk here with the food gradually defrosting. That's fine. When you start running into trouble is when the supermarkets say, oh yeah, but we've got loyalty cards as well. And we can see when the trolley comes to the checkout, and we know which loyalty card was swiped through that checkout. And in the interest of providing a better service to our customer, we'll send that loyalty card, a letter saying, do you realize you could have bought this better product? You know, this all looks very good from a business point of view, even from a customer service point of view. But I'm way outside the original purpose. And if I haven't got controls to stop that sort of thing happening, then the original data collection is probably dodgy. So you have to have the controls in place when you collect the data to stop this sort of mission creep that says, well, I can improve the service a little better. And suddenly the intrusion starts getting bigger and bigger, more of a problem. In the network terms, in terms of communication networks, the 2002/58 directive lists for electronic communications networks the recognized purposes. Now, it is recognized that all communications networks have to do billing. They hadn't heard about NRENs, obviously. But there is a perception that billing is a vital function. You need to be able to track people to be able to bill them for phone calls. Or for traffic management, for operational purposes. Again, the law recognizes that operating a network sometimes requires you to breach privacy, and the law says, as long as it's necessary, proportionate, and controlled, that's fine. Prevention and detection of misuse, again, is a listed purpose. Providing value-added services. Some people actually like to have services that depend on knowing where the mobile phone is. You know, there are services where you can ask my mobile phone, where is a nearby restaurant? You know, if you're asking for that service, you're saying, and you can look and find out which cell my mobile phone is in. It should be clear in the agreement when you sign up to that service that you are now buying a value-added service for which I have to store more, collect more data about where you are. But again, the law says, yes, fine, no problem. Research, the one I keep getting asked about. Not clear. Research isn't listed. However, a lot of research is useful for operations, he says. They're also in UK law, and if anybody knows about other laws, I've asked around a bit over breakfast this morning, whether there is also a similar provision in other countries that says that for research you may actually be able to hand over unanonymized data as long as it is not published in unanonymized form, as long as only anonymized stuff is published, and as long as there are controls, again, to ensure that the researchers or whatever happens in the research doesn't harm the individuals or the organizations that the data is about. So there is a possibility there as well. But certainly putting stuff in planning, operations, I'm doing research, let's say, just to look at traffic volumes. There were some interesting figures from Di Davis yesterday on the efficiency of use of networks and packet loss. That sounds like highly useful information in planning a network. So I'd hope there was no problem at all in law in saying, okay, that's a valid purpose for which we can use the data. Almost always, however, you need to tell users beforehand what you're doing. In some cases, it's actually a good idea to tell users anyway, if you're interested in preventing and detecting misuse. Now, don't let users think they are anonymous. Don't let them think nobody's looking. Don't give them exact details. With a bit of luck, they'll think you can look and see more than you can, and it might discourage some. Different laws, different sorts of breach, you may have to give a general notice. Just publish the fact in your data protection registration, we record the following types of data for the following kinds of purpose. That's a general notice. It's stuck on a very obscure website and you need to know the exact legal name of the company to find it, but it's there. You may have to give specific information. If you are monitoring content for the purposes of enforcing an acceptable use policy, certainly in the UK, you have to give specific information by doing things like sticking stickers on screens and saying all use of this computer is subject to these terms and conditions, and we will monitor the use to make sure that the terms and conditions are abided by. But you need to actually make sure that every user knows, not just stick a general notice up somewhere. And in a few cases, if you're being very intrusive and the purpose is a bit woolly, you may actually have to get specific consent from every user of the system. That's probably only going to be possible if you've got your own little bit of wire that you're doing research on, and you know who those researchers are. But if you do that, and if you can say to the users, look, we have this other purpose, we want to be able to monitor all the traffic on this network, and the law gives you that possibility. It says you can do that. None of us, not true. 1 or 2 European countries, when something is European law, it is automatically national law. In most cases, member states actually have to implement the law. I am subject to the law of the UK, plus some European law that the UK hasn't got round to implementing yet. But mostly, UK law is what affects me. So there will be 25 implementations of the Data Protection Directive. But because the Data Protection Directive is so specific, so precise, so detailed, it's likely that most countries will just have taken the directive and pretty much copied it. Certain countries have a bad reputation for gold-plating such legislation and saying, Europe told us we had to do this, and they've just snuck in 3 or 4 additional added things that they wanted to do as a matter of policy. The UK has done this on occasion. But pretty much the laws derived from the Data Protection Directive will look pretty familiar. And if you're complying with your own national laws on that, it's likely that you won't be too far off complying with everybody else's. So in the UK, we have the Data Protection Act 1998. Note that the dates follow 95 Directive, 95 Data Protection Directive. UK passes law in 98. Well, we're supposed to do it within 2 years, but never mind. And the Electronic Communications (EC) Directive regulations in 2003 implement the 2000 Electronic Commerce Directive. So again, 3 years. We were a little bit late, but we got there. The Article 8 of the Convention has much more room for variation. It's a 2-line statement. So countries can put a lot more of their own culture, of their own understanding, of their own expectations in there. So you're much more likely, if you're having to comply with whatever law derives from Article 8, you're going to find much more variation between countries. There's an interesting comparison. If you take the UK and the Netherlands and ask people which of those 2 countries is the more liberal, the more open, most people would find that a fairly easy question. However, if you look at interception of networks by the police, which comes straight from Article 8, the Netherlands police are allowed to do, I think it's 10 times more interceptions than the UK police are by law. So UK law is actually much more protective of the citizen and much less helpful to the state than the Dutch law is. And we had a huge fuss in the newspapers about getting even that level of protection in. And I'm told that in the Netherlands it just went through with nobody thinking about it. So you get some very odd effects in this area, and things are not always as you'd expect. Again, the UK implementation is the Regulation of Investigatory Powers Act 2000. So that's the European stuff. the sort of thing you might find if you look, go and find out what the requirements are in your country for the two types of activity that have privacy issues, passive monitoring and interception. And these are for three purposes from the Electronic Communications Directive, plus research, which is the one I keep getting asked about. Operational purposes, if you're doing passive monitoring, you need to notify users, but only notify. Just publish it somewhere. If anybody really wants to know, I'll show you where ours is in a couple of hours. It's quite hard to find it, but it does exist. For detecting misuse, again, you need to notify users. Have a notice published somewhere. For a value-added service, you have to notify, but the user can opt out. So it's fine for a mobile phone company to turn on triangulation of phones by default, but there has to be a provision for the user, for an individual user, to say, I don't want you to do this, which means you actually have to keep a record of which users have opted out. Research, passive monitoring, I think very much depends on the purpose. Some types of research, it appears we might actually be able to get away without any additional notice. You've still got to have the original purpose for collecting the data, but adding research may not require you to do anything. It may require you to add an additional notice, or it may, in fact, on some occasions, require you to get consent. And consent has to be positive. When I'm saying consent here, I mean somebody ticking on a box saying, yes, I agree that you can do this. You can't say it's a condition of use of this network that you consent. That'd be like, what was your example, Andrew? Saying to a student, it's a condition of coming here that everything you do while you're here is the property of the university. That just won't fly. Interception, the requirements are somewhat harder. In fact, operation, interception doesn't add anything extra, but you still have the notification requirement by the Data Protection Act. Misuse, you probably need to take, as it says in the Act, all reasonable measures. Whether sticking stickers on all terminals is enough hasn't actually been tested yet. If I walk into a site that does interception with my laptop, I connect to the wireless network, I haven't got a sticker on my screen. Have I been informed? Have they taken all reasonable measures? There's also an interesting challenge as to what all users means, because if you are intercepting your email system, there are local users. You can probably find all of those, but do you actually have to take all reasonable measures to inform all possible senders, i.e. everybody out there on the internet? That is as yet an unanswered question. I think the law is going to be reasonable on that. I hope so. Misuse. You may have to get consent in some circumstances, depending on what the definition of misuse is. Asking people to consent to being monitored so you can detect their misuse might be an interesting challenge to phrase that one to get any yes answers. Certainly value-added services, the only way you can do interception to provide a value-added service is to get explicit consent from the user. If it's a service that they see as added value, they may be happy. They may say, yes, I want to sign up for that, but you can't subscribe them by default and wait for them to not do it. And again, research, I think, pretty clear. If you want to look at the content of messages for research purposes, you need to get the consent of all users. But actually, isn't that, if we're users, the sort of thing we'd expect anyway? There are some things, we expect people running networks to do what's necessary to run networks. But we probably don't expect them, without telling us, to do research on how often do you use the network, when do you log in, how many emails did you send. If you're processing that sort of data about me, I'd like to know. So, apologies for repeating a slide from yesterday, and apologies to those who were at the TFC CERT meeting in Zurich who saw the slides. I think the talk's been a bit different. But if you're doing anything, if you're monitoring your network, if you're doing performance measurement, think, why am I doing it? Be clear. Know exactly why you're doing it. Is the risk if I don't do it greater than the breach of privacy if I do? A helper to that, if the answer first time round came out, no, the risk isn't greater, one thing you may be able to do is, can I do this in a less intrusive way? And I can tip the balance in that second bullet point. For example, if you're processing any sort of data, if you're processing header data, it's regarded as less intrusive if you get a computer to do it than if you get somebody to do it as a human looking through a listing. Sort of, again, it matches our feelings. If there are logs of all your web browsing, would you rather have a computer searching through it, looking for particular sites, or would you rather have me as a sysadmin looking through and say, oh, he's been booking his holiday, has he? During my talk, somebody out there has been booking their holidays. It's less intrusive if you get the computer to do it. How long do I need to keep the data? This is one of the very key points in data protection legislation, is you mustn't keep data longer than necessary. So be clear, how long do I need this for? And as long as you can justify it, the law will usually say, yes, fine. How will I protect it against misuse? And of course, the shorter period you keep the data for, the easier it is to protect it. So there's a trade-off there as well. Do I need to inform users? Have I informed the users? Do I need to get their consent? Those are probably standard questions. Once you know the answers to those, you can then go and look at your national law and say, am I within my national law or not? And if you're thinking like network managers, if you're thinking like researchers, remember that you are people. And sometimes what people want will actually override what you, as a network manager or as a researcher, want. From looking at the law, I don't think that will happen very often. And if it does, it's probably a sign that you're trying to do something unreasonable. I've certainly found the law quite helpful in establishing what is reasonable and what isn't. It's not necessarily something to be scared of, but it is something that you have to be clear what you're doing, why you're doing it, and how you can do it with the least harm. Thank you.
Thank you very much. This was enlightening. Questions? There.
Just a question. When you do research, you have to ask or you have to ask the respondents if they will allow it. But in order to ask it, you must send them an email or something, and that's spamming. Mm-hmm. So how do you cope with that?
It probably depends. The first point is, if you're doing research, it will depend what the research is for, whether you have to inform them. If you've ended up in a situation where your purpose says, I need to inform them, but it's such a big community that you don't already have a relationship with them, therefore they'll perceive you as spamming, at that point I'd start questioning my motives and saying, should I be doing this at all, or can I do it a different way? This is, I think, how I'll be using the law is as a check to say, is this reasonable? Yes, spamming is definitely covered by data protection law, which is enforced with more or less enthusiasm in different countries. I didn't cover enforcement at all. There is the same regulations on spamming in every country, but the Danes have already fined somebody €50,000 as a criminal offence. In the UK, I don't think anybody has been fined anything for spamming. A couple of people may have had a mildly rude notice, not from the enforcement people, but from their own business organisations, to say don't do this. But there are big differences there as well. But actually, as research networks, I really don't think we should be relying on effective enforcement. We've committed a crime, but it's not one that our country thinks is very serious. That's not a position I want to take.
Other questions?
Yeah, David Simonson from UNIC, working with EduRoam and trying to sketch up which rules apply in the landscape of EduRoam Europe. I've come across, and you also mentioned it here, that the EU directives apply to open networks. And how should we perceive NRENs then? Are they open or are they closed? I mean, we can shut them off. We have fairly well-defined user base and relatively well-defined.
10 million of them. Yeah.
Still, most of us perceive them as closed.
Certainly in the UK, the telecoms regulator has stated that Janne is a private network as far as telecoms regulation is concerned. However, if you went to your users and total silence, I've been censored, that's all right. If you go to your users and say, do you feel that you have different rights when you are sitting in your university or your school from when you're at home connected to your commercial ISP, the law may say, yes, they are completely different, but again, I'd rather not go there. There is certainly the 2000-258 directive only applies to public networks. Whether an NREN is a public network probably depends on a country. But when I looked at this and thought, okay, my immediate thought was, yes, this gives me lots more freedoms. And then I started thinking about how my users would think of me if I started sitting in law. If I'm sitting in court chopping logic and saying, well, actually, I'm a private network, so this doesn't apply to me. Again, this doesn't really sound like somewhere I want to be as an NREN. I'm sort of aware of that loophole, but it's not one I want to use, or not one I want to rely on. I might be happy to use it if somebody really starts kicking up a fuss. And I just want to say to somebody, look, go away, this doesn't apply. But I'd rather not write my policies out into that loophole.
Thank you, and let's give a big hand to all our speakers today. Enjoy your lunch.